Welcome. We'll review the strategy for custody from a single father perspective. We will cover the winning strategies as case law and techniques for winning custody and visitation. But first, I am not a lawyer, and this is not legal advice. We're going to cover some strategies and techniques for winning your case. What is the definition of fatherhood for your offspring? Do you know? Well, a father is a natural guardian of his children, entrusted with their custody and nurturing, as entitled to the enjoyment and the benefits of their labor. In other words, it's rooted in the case law called prime versus foot. Battle for custody. Why? It's your offspring, correct? Well, you want to battle for custody because you want to take part in their education, school activities, sports. You also want to have weekly visits, vacations, holidays, as well as medical emergencies, prescription, and serious illness. You want to be involved in your children's life, even though you are not married to the mother or you are single. I have another video. It's called Fathers Have a Chance in the Custody Battle, whether you're single or you're married. Please review this video. Review your finances with a certified public accountant, because the battle for custody will, involve your finances. Also, you need to interview, or you have a friend who is a tax professional. Again, battle for custody involve finances, budgets. Now for a reality check. There is a new Department of Justice letter, it's called the DOJ letter, and you can file it into your family court's case. And you can get it at childsupport.newzenler.com. Hello, my name is Chris, and in this session we will review the battle for custody, a single father's guide to child support and visitation. I am not an attorney, and this is not legal advice, but I give you the basic premise or case law about child support. Let's get started. You can also listen to us on our podcast. We're available on all the major podcasts, Spotify, Apple, and Google. Also, we ask for a donation. Yes, we are asking for a donation. All this research that we're providing, it takes time and energy, and we're just asking for a small compensation just to keep our channel going. And if you have as small as a $5 Cash App, we're welcome. We're asking for a $25 gift donation, but again, any amount will be accepted. You can download our app where we have all of our videos and downloads, and it's available at childsupport.newzenler.com. The battle for custody and the battle for child support are two distinct processes. Like, for instance, in Texas, they want you to go to child support because they make money at it, but they don't tell you that it's a custody battle. And what they do is they steer you towards child support in many of the states, such as California, Indiana, Wisconsin, because why? They make their money. But child support and battle for custody are separate. We have a video called Child Support or Custody or Visitation. Please review that video. We describe what is child support and what is visitation and custody. So in the battle for custody, we are making a distinction. Child support. Child support, the official name is the Office of Child Support Enforcement, and the statute is 45 CFR 303.1, which is called a single and separate unit, and it's in the Department of Health. So how does child support gets enforcement? They installed what is called the Child Support Agency, and that statute is 45 CFR 302.34. What they do is they hire attorneys in which to either charge you or sue you for child support. And this is what they do. They rent spaces in the family court. So you're thinking that, well, I'm in the court building, but the actuality is they're renting space in the court building. This is how they mask, or I said they appear that if you are in court, but you're in child support agency. Why are all the states participating in the child support program, or Title 4D? Because the federal government pays each state what is called the incentive pool, which is 42 USC 658.A, the incentive pool.
For fiscal year 2024, the incentive payment pool is established at a total of $713 million. This pool represents the funding that will be distributed to states as financial incentives for their performance in child support enforcement programs. The incentive payment pool is designed to reward states for their effectiveness in managing child support enforcement programs, with a focus on performance, accountability, and accuracy.
We have a video called Mother Did Not Put You on Child Support. It's the state put you on child support. And here's why. There's a case law called Blessing versus Freestone, which is child support has nothing to do with the mother or the child. It's a yardstick for which the secretary is involved in the program. So the mother did not put you on child support. Watch that video. In addition to Blessing versus Freestone, please review the 5 Supreme Court cases that you should already know. The Supreme Court has looked at this, minimum 5 times, and they agree that the mother has nothing to do with child support. It's a state put you on child support. So please review the 5 Supreme Court cases that you should already know. Why are the states participating in the child support program? Because why? They want to, they want the incentive pool, which is 650A. But the purpose is, in order to satisfy this program, they want to separate your children from the fathers, which is called the abandonment clause. Again, the reason why the states participate in the child support program, because they're going to satisfy the abandonment clause. Each state has what is called the abandonment clause, which is when you come to family court, they're going to steer you towards child support, but they alleged that you have abandoned your child in order to satisfy the incentive pool which the federal government provides to all 50 states. So here's the code for, a table of contents. These are Alabama, Alaska, Arizona, to name a few. I give the example of the New York law, with the abandonment, which is 260.05, non-support of a child in the second degree. That's the abandonment laws. You should know Article 1 versus Article 3, which is the judiciary. In other words, Article 1, jurisdiction, is not the part of the judiciary branch of the government, which is, and Chief Justice John Roberts Marshall says that in order to enact a law, it must be reviewed from an Article 3, which is, the case law is Northern Pipeline Construction versus Marathon Oil. Why should we care about Article 1 versus Article 3? The reason is it's as a result of jurisdiction. Jurisdiction is a cornerstone of our judicial process. Without it, the courts cannot rule. We have a video called 1 and 2, and we discuss jurisdiction. This is all part of the New Deal from 1935.
The program was created under the name Aid to Dependent Children, ADC, by the Social Security Act of 1935 as part of the New Deal. It was created as a means-tested entitlement which subsidized the income of families where fathers were deceased, absent, or unable to work. The federal government required authorized state discretion to determine who received aid and in what amount. In 1961, a change in the law permitted states to extend benefits to families where the father was unemployed, a measure which 25 states eventually adopted. The words "families with" were added to the name in 1962.
If you're not married to the mother or you're a father, you need to go through what is called acknowledgement of paternity. This is the contract. And here's the state statute, 45 CFR 264.30. And it states that the state agency must refer the appropriate individual in the family for whom paternity and child support is being administered. This is not legal advice, but my issue is you need to establish paternity outside of the court system, outside the family court system. And again, this is not legal advice, but my suggestion, you need to do it outside of the court. The reason why I suggest that you need to take the paternity outside of the court system, because here's the case law. The sole purpose of paternity proceedings was to establish the father's obligation to pay support. And the case law is called Public Works versus Kohler. But if you're battling for custody, then you have to do a different route. You're going to file a declarative judgment in the Supreme Court or Circuit Court. And the case law is Cordell versus Woods. If you are not familiar with the history of child support, preview that video. If the mother is on welfare or any government assistance, they will determine that. And the statute is 45 CFR 303.5. So now that you've established paternity, so the court sees you as a different category of fathers: presumed father, the alleged father, the biological father, or the legal father. Pay close attention here. Only the legal father pays child support. The biological, the alleged, and the presumed father does not pay child support. In the state of Georgia, you go through the process called legitimation. Here's the issue. What is legitimation? If you're a single father and you're not married to the mother, then the mother has ultimately control of your children or child. You have to go through legitimation, which is the mother has sole control of your offspring, which is no parental rights, no decided on education, no medical, and no extra activities. You conduct all family cases on your own. The statute is 28 U.S. Code 1654, and it reads, "In all courts of the United States, a parties may plead and conduct on their own, whether personally or with counsel." And here's another case law. You have the right of access to the court. Remember, your First Amendment right is to have access to the court. And if they don't give you access, then your case is over. And the case law is Biffle versus Morton Rubber or Ryland versus Shapiro. So that means you can conduct your cases on your own.
The right of access to the courts is basic to our system of government, and it is well established today that it is one of the fundamental rights protected by the Constitution. I have the right to access the court at any time. This means that legally, a document is considered filed at the moment it is delivered to the clerk, even if it hasn't been officially marked as filed yet. This principle ensures that my ability to engage with the judicial system is not hindered by administrative delays or technicalities. The right to access the courts is a cornerstone of our system of government. It is a fundamental right that is firmly established and protected by the Constitution. This right guarantees that I, along with every citizen, have the ability to seek justice, challenge injustices, and have my voice heard in a court of law. It underscores the importance of an open and accessible judicial system as a key component of a fair and democratic society. The case laws are Biffle versus Morton Rubber Industry and Ryland versus Shapiro.
If you're in front of a judge and the judge says, well, you need to get counseling, remember, the case law says they cannot force counsel upon you. And it reads, the law does not say that you can have you have the option of counsel, but you can plead your case yourself, and which is Moore versus State of Michigan. The Supreme Court has dealt with custody battles, so you can use Stanley versus Illinois.
In Stanley versus Illinois, the United States Supreme Court considered whether a state law presumption that unmarried fathers weren't fit guardians violated the Constitution. Peter and Joan Stanley lived together off and on for 18 years and had 3 children together. The couple never married. When Joan passed away, the state of Illinois took custody of the Stanley children based on a state law that presumed unmarried fathers weren't fit guardians for their children. Illinois law had processes in place to take children into state custody on the basis of neglect or dependency. For neglect, the state could remove a child from the parents following proper notice, a hearing, and a finding that the parents were unfit. Dependency removal was permitted if a child had no living parents or guardians. The dependency statute defined parents in a way that excluded unmarried fathers. Therefore, Peter wasn't considered to be a surviving parent, and his children were taken into state custody without any notice or finding that Peter was an unfit parent. Pursuant to a state dependency hearing, Peter's children were declared wards of the state and placed with court-appointed guardians. Peter appealed, arguing that he'd been denied his rights to constitutional due process and equal protection. The Illinois Supreme Court affirmed the guardianship proceeding.
The states must obey the decisions of the Supreme Court, and they cannot refuse to follow them, which is, the case law is Cooper versus Aaron. Likewise, when you're in a custody battle, always a reminder that it's the 14th Amendment, the guarantee to right to privacy as well as right to rear your children as you see fit.
The 14th Amendment. No state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States. No state shall deny to any person within its jurisdiction the equal protection of the laws.
Here are some other case law. Stephen L. versus Caroli A. It was decided in Monroe, New York County. And it reads that magistrate and commissioners discuss child support, but you're involved in a custody battle. That means an Article 3 judge must be decided for custody and visitation. The reason is it's a complete lack of jurisdiction. And what I'm saying is, don't confuse child support with custody. Here's another case law called Lillian T. versus John T. And also, you have the right to sue.
Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory subjects or causes to be subjected any citizen or other person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution and its laws, is liable to the party injured at law, suit in equity, or other proper proceeding for redress. In any lawsuit brought, the plaintiff must prove that he or she has been deprived of a right secured by the Constitution and laws, and secondly, that the defendant was acting under color of any state law. Absolute provides legal protection to judges, prosecutors, legislators, and some executive officials for actions committed in their official duties without malice or corrupt motives. Absolute immunity protects these individuals from both criminal prosecution and civil lawsuits. Qualified protects a government official from lawsuits alleging that the official violated a plaintiff's rights, only allowing suits where officials violated clearly established law. The plaintiff must prove 1. That he or she has been deprived of a right secured by the Constitution and laws, and 2. That the defendant was acting under color of any state law.
When battling for custody and visitation is very, very complex, but I hope in this video I at least give you the basics so that you can plead your case yourself or with counsel. Now, you can schedule a consultation. If you have any questions or comments, please feel free to email us at chrish@289.protonmail.com. Please like and subscribe to our YouTube channel and press the notification bell. We conduct research and we provide the appropriate material for this topic. Also, we're asking for a $25 gift